serving as officer of the Supreme Court Registry, representative of Bangladesh Judicial Service Association, Bangladesh Women Judges Association, UNDP representative, the US Embassy Dhaka representative, my learned lawyer colleagues, distinguished guests, and all the champion of justice that you are present here today. It's an immense privilege to stand before you today to discuss a judgment that redefined the constitutional and judicial landscape of Bangladesh. The judgment that we are talking about here is a historic judgment, and all of you very well know about that, the Mazda Hussain judgment. I must be deeply thankful to Honorable Chief Justice because he has covered in his speech almost the entire conceptual framework that I prepared to deliver as my keynote speech. So I am truly relieved and I am feeling really light that I do not have to go through my entire script that I have prepared, and by now I am sure that you almost everyone has a copy of my keynote speech. So I will request you to go to directly to page 9, and I will start from section 24 of my paper. And I hope the aspects that needed to be covered to justify the topic that we have selected, it is enough that if I read out and share my understanding and thoughts from these pages. So I have named this as last battle. So why last battle? It needs a justification. Syed Ishtiaq Ahmed tirelessly endeavored to mold the nascent Bangladeshi judiciary, aligning it with nation's constitutional framework. His remarkable efforts culminated in a masterful presentation to the judges. Despite his esteemed reputation as a distinguished jurist, an exceptionally successful lawyer, and a highly revered national figure, one of his most profound achievements lay in the judgment of the Mazda Hussain case. In this landmark ruling, he eloquently articulated his vision and embedded the very essence of judicial independence for a nation. While not all his arguments were ultimately accepted, this verdict nonetheless represented a milestone victory. Throughout his life, the principle of judicial independence remained central to his cherished values. The Mazda Hussain verdict was pronounced on December 2, 1999, and Syed Ishtiaq passed away 3.5 years later on July 12, 2003. Prior to his passing, he served as law advisor from July 15 to October 10, 2001. This role presented him with a historic opportunity to implement this momentous judgment. However, it is understood that the then incumbent Prime Minister requested a temporary deference of its final execution. The intention was for her government to oversee the implementation and thus be associated with this historic achievement. Syed Ishtiaq Ahmed honored this commitment, but regrettably, the execution did not proceed as promised. And another extraordinary aspect that we can share and discuss about this Mazda Hussain judgment is the following paragraph that I would like to read out. Astonishing assembly of legal minds. We must celebrate the tremendous achievement of this verdict, but beyond its many merits, a single exceptional aspect elevates it to truly a special and extraordinary status. The Mazda Hussain case is arguably the last case that brought together some of the last remaining finest legal minds in the history of Bangladesh judiciary. This case featured an extraordinary lineup of legal talent. Mr. Mahmoudul Islam served as Attorney General, while Dr. Kamal Hussain, Syed Ishtiaq Ahmed, and Amirul Islam appeared as counsel for the defendant. These four are widely considered among the greatest lawyers ever produced by this bar. Equally important were the judges presiding on the bench. Chief Justice Mustafa Kamal, a towering figure, and his other companion judges were Mr. Justice Latifur Rahman, later Chief Justice of Bangladesh, Mr. Justice Bibi Roy Chowdhury, Mr. Justice Mahamudul Amin Chowdhury, later Chief Justice. It was indeed an astonishing assembly of legal minds that was gathered in the Appellate Division and was formulating the Mazdarussian formula. Among those involved, however, three names, and I would call this the magnificent trio, stand out due to their historical association. Syed Ishtiaq Ahmed and Mustafa Kamal were close friends since their university days and were ardent supporters and activists of 1952 language movement, a pivotal event that ultimately defined the nation's independence in 1971. Their friendship remained strong throughout their lives. They both studied in England, attending the London School of Economics, doing bar at law from Lincoln's Inn, and returned to Bangladesh around the same time, which is early 60s, the most formative years before the birth of this nation state. While they were popular cultural and political activists in university circles, and many expected them to enter politics, both chose the legal profession instead. Ishtiaq remained a lawyer for the rest of his life. Mustafa Kamal, though initially reluctant and having declined elevation twice, became a Supreme Court judge in 1979. Justice Mustafa Kamal authored several landmark judgments that caused a paradigm shift in Bangladesh's justice landscape, legal culture, and judicial administration. While Syed Ishtiaq Ahmed continued his vigorous advocacy for civil liberty, rule of law, democracy, freedom of press, and constitutionalism. In the early 70s, Mahamudul Islam began collaborating with Barrister Syed Ishtiaq Ahmed. This bond lasted until Ishtiaq's death. Islam served as Ishtiaq's junior counsel for more than 2 decades. Together, they fought several landmark cases involving critical constitutional issues. Many of these decisions are still consulted today as precedent. The jugalbandi of these two extraordinary legal minds, Barrister Syed Ishtiaq Ahmed and Mahamudul Islam, the jugalbandi of Ishtiaq and Mahamudul Islam and their extraordinary contribution during 1980s, ingeniously preserving the light of constitutionalism, deserve a complete separate investigation. This collaboration culminated in the landmark 8th Amendment judgment in 1989, which established the principle of constitutional supremacy for the first time in our history. Their jugalbandi continued until the mid-90s. Therefore, the Mazdarussian case represented a full circle of life. In this case, we saw Syed Ishtiaq Ahmed as counsel, his most intimate friend Mustafa Kamal as Chief Justice, and Ishtiaq's most beloved junior, Mahamudul Islam, as the main opponent in and as the Attorney General for Bangladesh. What a spectacular demonstration of legal intelligence and jurisprudential wisdom. In this light, the case can be viewed as a classic example of an epic battle between the mentor and his most brilliant disciple. এটা প্রকৃত অর্থে একটা গুরু শিষ্যের অসাধারণ লড়াই ছিল এই Mazdarussian case. And the role of umpiring at that time fell upon a tested, lifelong comrade, none other than Chief Justice Mustafa Kamal. So this was the basic thing that I wanted to cover. Apart from Honorable Chief Justice, what he said, he actually set the fundamental tone of impact of future and the present state of judicial independence in Bangladesh. Therefore, I would not really go through the rest of my papers. Rather, the distinguished panelists and discussions who are sitting in the podium, everyone is eagerly waiting to listen to them, what they have to say. And I can take this excuse because what I will read now, it is already in your hands, so I really do not have to go through the entire manuscripts. But of course, bear me so that I can at least finish my concluding remarks. So if you would please come to page 15, which is section 43, concluding remarks. The Mazhar Hussain case remains a pivotal moment in the constitutional history of Bangladesh, which can be characterized as Barrister Ishtiaq Ahmed's last battle. This judgment represents a profound constitutional struggle, redefining the constitutional landscape regarding the judicial independence. Ahmed's argument, rooted in a radical rethinking of constitutional scheme, I believe, emphasized achieving functional independence within the existing framework of the constitution. He was very, very particular and different from other counsel arguing this point. He uniquely contended that the phrase consultation with the Supreme Court used in Article 116 required teeth, and the primacy of the Supreme Court's view, given that the real power rested with the Prime Minister, the head of the government. The Mazhar Hussain case is not just a chapter in our legal history, it's a living testament to the power of constitutional advocacy. In light how persistent and principled legal battle can reshape very fabric of a nation's government. Section 45. This case, featuring an astonishing assembly of legal minds, including Syed Ishtiaq Ahmed, his close friend Chief Justice Mustafa Kamal, and his former brilliant junior Mahmoudul Islam, provided a definitive roadmap and critical momentum for judicial independence. As a living testament to the power of constitutional advocacy, the Mazhar Hussain case demonstrates how principled legal battle can reshape the nation's governance. We must honor this legacy by striving for a judiciary that is truly independent in spirit and in function. I am truly honored that I have been given this opportunity to speak a few lines, few words before you. Thank you very much, and a very good evening again. Thank you.
Thank you very much, Mr. Arif Khan, for that informative and thought-provoking keynote speech. This has very ably set the tone for the panel discussion that is to follow today. And your insights have actually provided us with a very strong foundation upon which we can build a meaningful dialogue. Just a few words before we actually kick off the panel discussion.